All right. Seeing no other questions in the chat, we'll move on to our next session on contracting legal aspects of pediatrics. And I would like to welcome our next speakers who are from Vorys, Sater, Seymour, and Peace, LLP. Jolie Havens is a partner in the Vorys Columbus and Houston offices and is the immediate past chair of the firm's healthcare group. She also serves as the firm's Chief Diversity and Inclusion Officer, where she leads the firm's strategy, policies, and practices related to diversity, equity, and inclusion. Jolie manages a national practice focused on healthcare compliance and provider or practitioner reimbursement with significant experience involving hospitals and physicians. And Nakia Knudsen is an associate in the Vorys Columbus office and is a member of the healthcare group. She has experience drafting, reviewing, and revising commercial and confidentiality agreements. Nakia received her JD from the Syracuse University College of Law, where she served as an editorial member of the Syracuse Law Review, and she received her MHA and BS from the Ohio State University. So a special welcome to you. So please add any questions that you have for them in the chat during the session, and we will direct them to our speakers. So welcome and thank you so much, both of you, for being here.
Thank you, Kelsey. We appreciate the warm welcome, and it's nice to be back with you guys again. As Kelsey said, we do significant work with physicians and children's hospitals. That's the bulk of my practice at this point. Everything from staying licensed to getting paid to staying out of trouble, and that includes a lot of physician employment agreements. We are, like one of our earlier speakers, also right in the thick of, reproductive rights issues, transgender and gender affirming care issues. But our topic for today is your first employment agreement. Yeah, and if you want to advance to slide 3, that's great. So we're going to talk about sort of what you might expect, how you might interact with an attorney if you choose to engage one, and some of the key provisions that you'll want to make sure that you understand. Our goal here, we're going to cover a lot of information in a relatively short period of time. So really our goal is just to get some issues on your radar. So that way, when you're in the process of this, or if you're in the process of this now, these are things that you're going to think about. And then we can obviously do a deeper dive as needed. And folks are certainly able to reach out to me or Nakia afterwards. If you have questions, we'd be happy to answer them for you. So kicking off, sort of the first piece of the puzzle here that we want to know is, what employment environment are we working in? There are, if you want to go back one slide to 3. Yep, thank you. Perfect. Some of you may be going into, hospitals or hospital-based groups. Other of you may be looking at, some type of government practice, or many of you are probably looking at large or small private practice employment post-residency. Each one of these contexts, each one of these environments have their own context, right? And their own unique attributes, and having negotiated agreements in all of them, I can tell you there are certainly, differences there. And, and then even within, the hospital sector or the group sector, everyone is different and has their own, peculiarities, if you will. So I think just starting out, having, working with your counsel, if you have one, and having some understanding of just sort of what segment am I in here, and how is this negotiation process going to look? So for example, in a hospital, you may be talking to, the physician liaison, or someone whose primary role is that physician contracting piece. When you're talking about a large or small group, they may not have that function. You may be talking directly and negotiating directly with, people who are going to be your colleagues if you come on board. So there are just different dynamics that can come to play there. And then obviously we've got the individual personalities piece that we always just like to know. Being legal counsel, we always like to know as much as we can about that. And then talk about, how we best understand that environment and maximize it as a part of the negotiation process. Next slide. So negotiation strategies are just things to keep in mind with respect to sort of what I'll call the dance. One of the first things you want to understand is your bargaining position. And, the reality of it is, and I'm sure this is not going to be a shock to you, when you're negotiating your first employment agreement, you're not in the strongest bargaining position, right? They may, put something in front of you and largely expect that you're going to, just sign it. We would strongly advise against, don't do that. You want to, at the very least, whether you engage legal counsel or not to help you negotiate, you want to make sure you understand what's in that agreement. Because you're coming to the table with, not the strongest bargaining position you're ever going to have in your career, we really talk about picking our battles and differentiating between, what do you want in there versus what can you live with in there versus what do you absolutely need in there. You're not going to get everything you want. We know this. But we do want to, figure out what's important, with your particular situation. And one of the biggest pieces that we're going to talk about a little bit later in the presentation as well is, everybody goes into these relationships thinking they're going to work out and be positive. And that is absolutely the hope. But the smart thing to do is also anticipate that may not be what happens. So we always like to enter into any new employment relationship, understanding also what is our exit strategy if we need one, and then what are those opportunities going to be at that time. One of the other things to consider as a part of this is tone, and that kind of also feeds into, if you do have a lawyer, how you might use that lawyer. So we step in a variety of contexts. We obviously do, younger physicians who are just beginning their career all the way through folks, who are very seasoned and have been practicing for a very long time. In terms of our role, that can either be, we can negotiate directly on your behalf with either, the folks at the particular provider or their counsel. Or sometimes, depending on the circumstances, the physician will kind of keep us in the background and do some of the negotiating on their own, either letting folks know that they do have counsel or not. So that can look a lot of different ways, I guess, is the point that I want to make. And, the goal there is to do what makes the most sense in that particular situation to get you where you want to go. And you have that flexibility in working with, your counsel to be able to talk about that and differentiate that. The other piece on tone that I'll mention is, we want everything to be amicable and professional, of course, but that doesn't mean that you have to just roll over and sign whatever is put in front of you. You absolutely should be reviewing things, asking questions, and making sure that you understand what the arrangement is that's being put in front of you, and that you go in fully eyes open, or as eyes open as you can be. Next slide. Key provisions that we're going to unpack a little bit that are going to show up in your employment agreement. So the job description and the requirements there, comp and benefits, really big issue. Outside activities. So doing something that is not directly related to your employment, but may still be in the physician practice space. Term and termination, restrictive covenants, and then obviously professional liability coverage is a big issue. So let's unpack these a little bit. Next slide.
So when it comes to the job description aspect of your employment agreement, you want to make sure that your agreement contemplates the various jobs that you might be doing. So this includes clinical services, administrative services, teaching or supervision, and research. You also want to make sure that there's an allocation of time for each of those. So let's say your employment agreement allocates 20% of your time for administrative tasks. You just want to make sure that that is explicitly contemplated in the agreement that you're signing. Another important aspect of this is going to be the location of services that is provided. We generally recommend that your agreement will state that you work at a location that's mutually agreed upon by you and your employer. The reason that this is an issue and we want to flag it for you and make sure you include it in your agreement is that depending on where you are placed, it might impact your productivity. If for some reason your compensation is tied to your productivity, then your compensation is going to be impacted based on the location that you are sent to. And therefore, we just want to make sure that your agreement states that you each have to agree to the location so that you have some leeway and leverage to sort of decide where you're working and what that looks like. Next slide, please.
Sort of tying into that is call coverage. And this isn't necessarily going to come up in every employment context, but certainly will if you are, looking at hospital-based work or even with a practice, depending on, what the nature of the practice is, but generally all of them. Sometimes agreements are a little vague on what those requirements are. And what you want to understand is, am I expected to do the call coverage? If so, how many docs am I splitting this with? Because, at times, particularly depending on what specialty you're talking about or if you're talking about a rural area that maybe doesn't have as many folks in a particular specialty, you can have call split amongst a very small group of people, which is a pretty substantial burden. to place on a physician. And then the question becomes, are you getting paid separately for call, or is call already embedded within your comp? And if it's already embedded, then you have to look at that as, not only the services that you're providing, as a routine part of your arrangement, but then what are the hours that you're going to be devoting to, being on call? And that might make, the compensation arrangements that's being put in front of you look very, very different. You'll also want to consider, to the extent you're on, a medical staff, for example, even if you're in private practice, you want to have privileges to be able to admit your patients, at local hospitals. Sometimes there are requirements there as well, obviously, for call coverage and different contributions that you're going to be making as part of the medical staff. So you'll just want to make sure that you understand those as well, sort of in the big mix of all of the contributions that you're going to be making, to make sure that you do feel that you're being adequately compensated, and that sort of your full array of requirements is something that you feel is manageable and that you can handle. Next slide. Comp and benefits. As you guys know, when we're talking about fraud and abuse laws, Stark and anti-kickback, the amount that you get paid has to be fair market value for the services that are provided. Now, employers have considerably more flexibility in terms of compensating their employees than they do, for example, independent contractor physicians. We're looking at slightly different compliance requirements depending on those two different relationships. Most employers have, a compensation program internally that talks about, what the process is for setting comp. They're going to potentially involve, third parties who may do some compensation benchmarking for them. And then they're also going to look at, survey data, like MGMA or others that are out there. So there's a variety of things that employers do when setting comp. And you just want to make sure that you understand, what is that process? Is there a written, compensation plan that applies to employed docs? And can you get access to that, just so you understand how everything is working? The two most common compensation models we see is either one or the other, but usually a combination of a salary guarantee in either your first year, sometimes your second year, and a WRVU or productivity-based model. Occasionally, we'll see a percentage of revenue from personally performed services. And, if that's the case, then one of the big issues that comes up is AR runout. So once you're no longer employed, are you going to continue to get paid for any of the work that you performed while you were employed? But again, that's a little bit more rare. So we're going to focus on the other two. The guarantee is just what it says. It just says for that first year, or ideally for 2 years, regardless of your productivity, generally speaking, you're going to be paid a certain amount. And, that's designed to allow you to become productive, whether that is increasing patient base, whether that is learning a new EMR, which can absolutely impact productivity, just kind of letting you get your employed doc legs underneath you, and being able to really build your practice. Then typically at year 2 or 3, you often move to an RVU or productivity model, which then is really tied to what are you actually doing? And the way that typically works is you're usually given estimated comp throughout the year, which is tied to like a prior year's productivity. And then there's a true up or a reconciliation that happens. And sometimes that's quarterly, sometimes it's annual. And essentially then you're comparing what have you been paid as sort of your estimated comp as compared to what have you actually produced within that period of time. And that can result in one of two things. Either your employer owes you additional money because you've been more productive than what was estimated, or on the flip side, there can be a time when you can actually owe the employer money if you've been paid more than what your actual productivity was. So if that potentially pops up, you want to make sure in your agreement that you have some flexibility regarding how that gets paid back. Otherwise, they're going to have their hand out and expect you to potentially write, a sizable check, which you may or may not have. So we usually like to build in, either that's going to be carried forward and will sort of be offset against future productivity, sort of a rolling true up, if you will, or we'll include in there at least a, 60-day period for, arrangements to be made for repayment of those amounts. But that's just something to keep an eye on once you switch from guaranteed comp to a productivity model. Your agreement may also contemplate certain types of bonus opportunities, a starting bonus, perhaps meeting certain quality metrics, as you're practicing, as well as a productivity bonus. So if you hit a certain WRVU threshold, then above that point, you may be eligible for, an additional bonus. So, and that varies by employer, but, we see all of those things pretty routinely. And then another component of your compensation can be student loan forgiveness. This can either be a separate agreement or it can kind of be embedded in your employment agreement. But long story short, what this is the employer effectively loaning you money that you are then going to work off to pay for your student loans. And what the law contemplates is that you earn the student loan forgiveness by working in this employer's service area. So theoretically, what that means is that you wouldn't have to continue working for that same employer as if you worked for another employer in the service area to continue getting that student loan subsidy and forgiveness. Practically speaking, what I always see is that when your employment ends, the student loan forgiveness ends. And in terms of documentation, what you would see is generally, like I said, either a separate agreement or built into your student loan or in your employment agreement. But there's typically going to be a separate, in that case, student loan addendum, and then promissory notes that you're going to sign, which are virtually identical and are always cognovit promissory notes, which essentially means that if you default, meaning you don't meet the work requirements to have the loan forgiven, then the employer can go and get a judgment against you without ever having to talk to you or give you notice. And then you might owe certain amounts back that haven't been unforgiven as a part of that. So anyway, just again, keep that in mind as you're moving forward. Next slide.
So as a general matter, your employment agreement is going to limit or prohibit other outside activities, or it's what you were doing, your description is going to be broadly drafted so that it, sort of prohibits anything else that may fall within the scope of what you're currently employed to do. So when you want to engage in outside activities, you want to make sure that it's either not contemplated by your employment agreement or arrangement, or what we see most often is that there's a process for approval for outside activities. So when you want to engage in those, you just want to make sure that you're following the process for approval that's outlined within your agreement, and that you're documenting and having in writing confirmation that you can engage or that you have gone through the process for approval for outside activities. Another thing to really consider is how your employment agreement contemplates compensation for work performed. So sometimes compensation for outside activities falls under your employment agreement, meaning that any compensation you receive is actually going to be the compensation of your employer and not you. So you're going to want to make sure that there's a carve out in your employee agreement such that that compensation comes to you and is not considered compensation of your employer. We want to make sure that you make sure this is clear and explicitly stated, so there's no question as to, whether your compensation is actually going to your employer or if you are rightly accepting outside activity compensation on your own. Jolie, is there anything that you'd want to chime in about before we move on?
No, I think that's good. I mean, one of the things we will do sometimes is if as a part of your arrangement that there's something that's very important to you outside of your employment that you want the ability to continue to do, we will negotiate that and put it directly in your agreement. We got a question. Can you comment about conflict of interest agreements? Yeah. So most employers are generally going to have a conflict of interest policy that's going to apply to all docs, which basically says, you can and can't have certain relationships because those are deemed to conflict with, what's being done by your employer. Then oftentimes, in addition to that, there will be an annual process for disclosing conflicts of interest. So, if you have relationships with potential competing providers, or if, your spouse or significant other works at a certain place, but it's a process of gathering information. And how that intersects with the outside activities piece is, generally speaking, employers aren't going to approve outside activities that they believe are conflicts of interest. So let's say you're working for an independent pediatric group. If you work for one and then you say, oh, well, I've got some capacity, I want to go work for this other one, the odds are they're going to say, nope, conflict of interest, can't do that, right? But if instead you're like, hey, I want to, you know, participate in some program at a children's hospital to help educate, or I want to do something else that is deemed to be sort of not directly competitive with what your employer's doing, then odds are you have a much higher likelihood of being able to pursue that outside activity. But that can be something that, as between employers and employees, can be quite contentious, actually. So as much as possible, if there are things you know you want to do, we like to describe those things and get approval for those up front, as opposed to sort of waiting until the relationship starts and then hoping that, you know, you can come to an agreement. That being said, there are certainly things that pop up, you know, midstream after your employment has already commenced, and we can absolutely deal with those, you know, as they come up. Thank you for that question. Anything else you want to add, Nikia?
Nope, that's good.
Okay, next slide. Restrictive covenants, everyone's favorite topic. So this is going to limit what you can do both during your employment and after your employment ends. And this comes up in sort of a couple of different forms. The one that folks I think are most familiar with is the non-compete, the one that says, you know, during, this kind of ties back into the conflicts of interest and the outside activities too, that during the course of your employment, generally speaking, you can't engage in activities that are deemed to be competitive with the professional activities of your employer. There are a few facets of this that are really important to understand. You know, we are seeing more and more employment agreements that don't have any non-compete at all, but many still do. Part of this, we think, is tied to, and you may have heard a little bit about this, the FTC is actually taking a pretty hard stance against non-competes as being anti-competitive. And they've issued a proposed rule which would largely eliminate, in our world, you know, all non-competes. So that way docs could move from one opportunity to another without having to deal with those. One piece that would be preserved with that, and where we found that courts are much more likely to actually enforce non-competes, is in the equity context. So in the context of, I'm not entering into an agreement as an employee, but I'm entering into an agreement to perhaps sell my practice. But I'm going to then remain employed. In those instances, those purchase agreements or those sale agreements, depending on which side of the transaction you're on, oftentimes have non-competes in them as well. Now, those do tend to be enforced more readily by courts than ones that are in the employment context. So looking at the non-compete, one of the first issues we need to look at is, what is the geographic scope? How many miles are you prohibited from doing something, and from what point? That from what point piece goes back to the location comment that Nikia made earlier, which is, we generally like to have it from your primary practice location. Oftentimes employers like to have it from any location in which you provided a service, or any location in which any services are provided by the employer. So you can see, depending on how you structure that, you could be dealing with, you know, a relatively small non-compete geographic area, or you could be dealing with a very large non-compete, you know, geographic area. What we typically see in terms of mileage is, I mean, we will see some that are quite large, but on the whole, you're usually looking at somewhere like 15 to 30 miles from whatever location point is selected. And again, that location point is important. You want to also think about the scope of the prohibited activities. Are you basically prohibited from doing anything, which is often what we see, which is, you know, providing any services, from, you know, doing any investments, doing any consulting, really anything within that period? Or are there still viable employment opportunities left for you? This is huge and goes back to sort of the exit strategy comment that I made earlier. If you are signing an agreement that has a non-compete, you want to make sure that you actually do have a viable employment option after, you know, employment ends. And, you know, that's something that folks can certainly fuss about at that point. But as much as possible, if we can control that on the front end, we want to, right? And then duration. How long is this restriction in place? What we typically see is a year, sometimes 18 months. Sometimes employers will try to push it well beyond that, but we're usually pretty successful in limiting it to, you know, 12 to 18 months. If you do find yourself in a situation with a non-compete that is potentially going to be restricting an employment opportunity that you want to pursue, you do have a couple of options. We could talk to the employer about a waiver. Sometimes agreements will include a liquidated damages provision, which essentially means an opportunity to buy yourself out of a non-compete, but oftentimes those amounts are incredibly high and sort of wildly out of proportion to the real damage that an employer would potentially suffer if you were to, relocate and do something that they would be viewing as, a competitive activity. This is not something to be ignored, though, I will tell you. I'm working on a matter right now where a physician unfortunately did that, and the physician's new employer is being sued for essentially intentional interference with a contractual relationship because of that existing non-compete with the prior employer. So you can really get crossways with a new employer if you aren't transparent about a non-compete that you have. And then if you, otherwise try to ignore it, they could be pulled into some litigation on that, which is obviously not a great way, to start a new relationship. Beyond that, another restrictive covenant that will come up is non-solicitation. So long story short, what that means is just they don't want you trying to poach patients and they don't want you trying to poach staff to go with you. But again, we just want to look at the scope there, and we want to make sure that, it isn't written so broadly to include, for example, advertisements to the general public, or, use of a staffing agency that might, place somebody with your practice or something like that. And the duration of that typically corresponds with the non-compete. Next slide. Term and termination. This is just how long your employment agreement's going to last. We commonly see 3 years with first employment agreements. And then usually, like we said, you've got a salary guarantee for that first year, sometimes 2, and then you go to a productivity model after that. The length of your employment agreement also ties into retirement plan contributions. So if your employer is going to be making retirement plan contributions on your behalf, there is a vesting schedule for those. And sometimes they aren't fully vested for a period of time. And if your employment ends before they're fully vested, then you don't get them. So that's something for you to consider, just in terms of, how all these different pieces work together. You want to make sure that all these different things are lining up, so you actually are getting all of the benefits that you think you're getting. Termination can typically come about in a few different ways. You've got without cause termination, which is just usually 30 to 120 days notice by either party. And that, either party can terminate the agreement for no reason at all. And the important piece to know about that is, even if you have an agreement that is, let's say, 3 years, but there's a 90-day without cause term, you really have a 90-day agreement. You don't have a 3-year agreement. So just recognizing that. Then we have with cause termination, and always in employment agreements, the employer has lots of reasons to terminate for cause. The employed doc may have rights or may not have rights. These are oftentimes incredibly vague, what these provisions are, and they're generally favoring the employer. So that's just, and employers typically don't change those. They aren't willing to negotiate too much on those. We're sometimes successful in, making a few changes, either including like a materiality provision or something like that. But generally those without cause, or those with cause terms can be, pretty significant and pretty broad. Another consideration relative to leaving employment is notice to patients. If you're leaving a practice, for example, there's a requirement under Ohio law that patient notice be provided regarding your departure. And we like to have a provision on this issue written into the employment agreement, which essentially says, and I'll give you an example, that, the group that was the employer, they will, provide the notice, they will pay for it, but that the notice will be jointly prepared. I've seen some notices come from employers that are incredibly one-sided, and make it sound as though following the doc is a very onerous process. And obviously, again, they're doing that because they don't want patient leakage. But that can be a potentially important issue if you're hoping to migrate patient relationships that you made during one employment opportunity to another employment opportunity. And then lastly, in this section, professional liability coverage. Generally speaking, in the context of employment, your employer is going to pay for this. Then a big issue that arises is whether or not you need tail. And that's typically a function of what kind of coverage is being provided. Is it claims incurred coverage, meaning as long as you had coverage in place when the circumstances giving rise to the claim happened, then you're going to still have coverage post-termination, or is it claims made coverage? Meaning, unless you have coverage in place when the claim is actually made, you're not going to have coverage for that particular professional liability issue. So it's incredibly important for this to be written into your agreement and for you to understand exactly what kind of coverage you have, who's paying for it, and particularly with respect to tail, who's paying for it, because sometimes they will try to shove that over off onto the doc, and that can be somewhat expensive. And what we like to do for some of these provisions, including, potential payment for, post-termination tail insurance or some things like that, we try to say, well, if the doc is terminated without cause, or if the doc terminates the agreement for cause, meaning the employer did something that they shouldn't have been doing, then, those provisions would not apply, meaning no non-competes in those situations, or, the employer is going to step up and pay for tail coverage. So there's different ways to manage these issues. You just want to make sure that you're aware of them and that you're actively managing them. Next slide. And then just a few other key provisions. I know we're running long on time a little bit. Other key provisions in an employment agreement that we wanted to mention and just get on your radar. Nikia?
Yeah, so the first one, which may seem sort of innocuous, but is actually really important, is the start date versus the effective date of your agreement. So we recommend that the effective date of the agreement be the day that you actually sign the agreement, regardless of when your start date is. The reason that this is important is, let's say you sign the agreement, but you're not going to start work for a month and a half, and they want to make the effective date the date that you start. You don't have the contractual, right to start your job or have any remedies under the agreement in that month and a half span of time, unless it takes effect the day in which you sign it. So that's a big one we want to flag for you. You want to make sure that your effective date is when you sign it, or is at least before your start date if your start date is a little farther out. When it comes to the incorporation of external policies, employment agreements tend to reference a bunch of different policies or documentation. You want to make sure you've reviewed all of those prior to signing any sort of employment agreement, because you want to make sure, one, you're in compliance with what those are, and that you understand what you're signing and what these documents are referencing.
On the confidentiality front, the way the confidentiality provisions are typically written is that what's deemed to be any kind of, and this is putting HIPAA aside, any kind of, business information or otherwise sensitive information of the employer, you can never use or disclose for your own purposes. Well, that doesn't take into account the fact that, you may need to talk with your lawyer about the agreement. You may need to make disclosures for purposes of enforcing the agreement. For example, if the employer were in breach. It also doesn't take into account any disclosures required by law or disclosures that may be needed to respond to a judicial, administrative, or public payer process. So we have specific language we like to include in there, which says, okay, we understand that we can't use or disclose this information except for in these instances. And we generally have pretty good results in being able to negotiate that. But it's just the idea being, if you try to enforce the agreement, you shouldn't be opening yourself up to a counterclaim that you've breached the confidentiality of your agreement. On indemnification, oftentimes agreements will have different indemnification provisions that require the employed doc to pay the employer group or other employer back for certain things. That could be related to prior employment. That could be tied to if there's a large overpayment. So you just want to understand if there's any requirement in there for you to pay your employer back for anything, you want to understand what that is, how much that might be, and whether or not you're willing to agree to it. It may or may not be something that they're willing to negotiate on, but it's important for you to understand that going in, because there could be a relatively hefty price tag tied to that. Medical records access post-termination, another big issue. Again, this is your right to defend yourself post-termination, whether that's in, a med mal suit or whether that's in some other type of payer, judicial, or administrative process. If your employer has all those records, you need to be able to get access to them to be able to defend yourself.
Lastly, when it comes to dispute resolution, a lot of employee agreements are going to have a required arbitration clause. We recommend generally going to court if there's an issue. If for some reason that can't be negotiated, you want to make sure that your arbitration or your dispute resolution clause specifies that it's an arbitrator who's approved by the AHLA, or the arbitration process is one that the AHLA will recognize. And you want to make sure that you get an arbitrator who understands healthcare. You know, the reason we recommend going to court is because when you have an arbitrator, they may not be familiar with healthcare. They may not be, you know, favorable to your side. And you may not know exactly what you're getting or what the process will look like. And it's not always actually cheaper than going to court. So that's another one to look at. Lastly, when it comes to the entirety of the agreement clause, you just want to make sure that anything that you've talked about or that is referenced in your LOI or any documentation is included in that agreement, because if it's not, you don't have the contractual right to that. So that one's important. And finally, partnership or promotion. This mostly comes up in the private practice context, and these tend to be notoriously vague. So if partnership is something that is important to you, you want to make sure that you look at this provision closely. What I mean by that is, you know, not per se the amount of years it takes until you're up for partnership, but what are the requirements for you to gain partnership within the practice that you are working with? And that, you know, you want to make sure that that's clear and explicit so that when it comes up to be partner, you are prepared and you know what the expectations are. Next slide, please.
And we're down to our last couple here, you guys. Just a couple comments here. Why negotiation matters. You know, your employment opportunities kind of build upon each other. So where you start out is going to absolutely have an impact on what you can do next. A non-compete restriction would be an example of that. So it's really important, even though this is your first one, it has the ability to, you know, impact your career well beyond this employment relationship. So you want to make sure that you're, you know, actively managing that again. We mentioned this a couple times, but just having that exit strategy, right? Everything looks like it's going to go really well in the beginning, but again, good endings are born out of well-negotiated employment agreements. And then just remember that in the beginning, you know, you're largely being hired by your colleagues and people that you have great relationships with. But when things go bad, there are going to be other people brought into the mix that you don't have those personal relationships with. So again, having all of that worked out on the front end is absolutely best. And then just lastly, a couple tips. We won't go over all of these, but just, oh, next slide, sorry. This is just, you know, about sort of being the good soldier in your new employment relationships, so you don't get the reputation of being sort of that physician, right? You know, fill out your credentialing pack early. The credentialing with payers can take a long time, or getting hospital privileges to the extent you're getting new ones. Just being responsive, you know, attend the meetings. It's going to seem like a time suck, but do it. You know, it's better for you to be there and to understand what's going on and to be seen as, you know, as much of a contributing member to your new employer as you can be. You know, understand your role and understand what leverage you have. And then the last comment we would make, and this is going to sound like a self-serving one, but it's really not intended to be. It goes back to the, you know, some of the issues we've talked about before. Sometimes we'll see folks who've had, you know, a family lawyer negotiate this for them, and then they'll find themselves in a position that they don't want to be in, and will be brought in at that point, and then we don't have quite as many options. So this isn't about us. This is just about whoever you do hire, make sure that you hire somebody who is familiar with the industry and understands beyond just general employment issues. They understand issues about, you know, your malpractice coverage and how we're structuring, you know, your comp model and all those different things that really are uniquely important in the physician context. And with that, thank you for listening, and we're happy to take any questions you have.